Well, greetings to those in New Zealand and Colombia. For me, it's an honor to lead this podcast with Professors Catherine Irons and Professor Felipe Clavijo Ospina, who are experts in rights of nature. To our esteemed professors and our listeners, welcome to this podcast. This is the podcast La Voz Jurídica from the District Legal Secretary of the Mayor's Office of Bogota. This is the second podcast in the second session of podcasts in 2023. The objective of this podcast is to share legal theory, some ideas for the legal team in Bogota and also for citizens in general in Bogota. Today, we are going to talk about rights of nature in the Whanganui and Atrato rivers. To achieve this objective, we have two guests who are experts in rights of nature. Firstly, we are with Professor Catherine Irons. She is a famous academic in this matter. She has extensive experience in international law, in environmental law, in indigenous rights, and in statutory interpretation, among others. Currently, she is research professor of law at Victoria University of Welligton in New Zealand. She has several degrees in New Zealand and also in the United States. On the other hand, we are with Professor Felipe Clavijo Ospina. He's a lawyer from Universidad Nacional de Colombia, as well as a research professor from Universidad El Bosque in Bogota. He was a clerk of the Constitutional Court of Colombia, where he drafted the judgment about the Atrato River in Colombia. Well, firstly, I would like to put this in context. So in general, rights can be viewed from a traditional civil law perspective. That is, only a person can have rights and duties. However, there are some perspectives that look on nature as a subject capable of exercising rights and duties. For instance, some indigenous communities see nature as the Pachamama or Mother Earth, which should be protected as a person. The Constitution of Ecuador recognizes nature or Pachamama as a subject of rights, where human beings must live in harmony with nature. Cases like the Atrato River in Colombia and the Whanganui River in New Zealand show how some indigenous communities perceive the water sources. Yeah, in their views, rivers have rights and duties. The Whanganui River in New Zealand became the first in the world to be considered as a person, as a legal person. This river, revered by the Maori's indigenous community, has duties and rights. This is because the New Zealand Parliament issued a law that granted rights and duties to this important river in New Zealand. And in Colombia, we have a similar case, the Atrato River in Colombia. Here, through a judicial claim, the Colombian Constitutional Court recognized rights to the Atrato River. The court took into account the vision of indigenous communities located near the river. The court granted legal status to the Atrato River and designated a group of people as legal representatives to for the defense and protection of the river's rights. So in this context, I would like to ask you some questions. Yeah. Firstly, I would like to know to know the following exactly. Could you tell us a little more about the context of the Atrato and Whanganui cases? For instance, the people who participated in these cases, yeah? Firstly, I would like to give the floor to Professor Catherine Irons, because the Whanganui case was before than the Atrato River here in Colombia. So Professor Catherine Irons, is an honor to be here with you.
Thank you, Fabio. I'm delighted to be able to share our experiences, and thank you for asking. So this river, we didn't get pictures. I know we're just having a conversation, but just in case, so people might not know much about New Zealand, but we are quite a large country in the sense of, it's like similar to the size of Italy, right? But we only have 5 million people. And it's a colonized country, a late settlement. Probably European settlers were really only starting in the 1800s. So we have a treaty with indigenous peoples that was signed, I would say, nearly 200 years ago. So we're actually still quite young as a country. So 1840 is when we signed the treaty with indigenous people. And of course, like all colonized countries around the world, that treaty got breached. More colonizers came. The lands that were promised to indigenous peoples didn't end up with them. They got taken away. There were wars, just like nearly all histories, wars with indigenous peoples. And the colonizers won, and they established the government. And so we now have a government that's based on the English, or the United Kingdom system, the British system, I should say, back then, of parliament and democracy, and a very Westminster style system. And so I'm giving you this background because that's actually the background to the river example. One of the things that, where control was taken away from the Whanganui Maori peoples, we say the tribes, the iwi, and I apologize if I slip into Maori words sometimes, but so the tribes up and down the river, they used to control that, and then that got taken away by the government and by other settlers, and they used to regard that river as their ancestor. So this is very similar indigenous philosophy, where you see yourself as part of the environment, as the parts of the environment are your relatives, like your grandparents. And so you have a duty to look after them. And they have this lovely saying in Māori, ko au te awa, ko te awa ko au, which if you transliterate it, it means I am the river is me. But it means more than that. It means when the river is healthy, I'm healthy. And when I'm healthy and I'm conveying my responsibilities to uphold the health of the river, then the river will be healthy. So it's like the river communities are all in one together. So when that got taken away from them through colonization, the Whanganui tribes had a big grievance. And of course, the country became educated about those grievances. And as a matter of human rights, of indigenous rights, the government started making reparations and trying to settle those agreements, give land back, give monetary compensation for all the takings that had occurred over, nearly 200 years. So the Whanganui River is one of those. It was as a result of agreeing to give something back for the grievance that the government made up this settlement agreement where the river became a person. So it's a very interesting agreement. So it's not one, like, we don't call it rights of nature. We call it a human rights. It's an indigenous rights agreement. Well, we say treaty rights. Why did they make it a person, though? Well, the tribe wanted to own the river. There's 8 tribes, but the tribes wanted to own the river. They wanted it back. The government was going, no, we don't want to give the river. Politically, that was very difficult. All the water in it, is worth a lot. And a lot of people have water rights to use it. So they were at an impasse. And the solution was, how about nobody owns the river? let the river own itself, and we together will be guardians. And that's how they came up with the solution of giving the river a legal personhood, personality. They made it a legal person, and then they made the tribes and the government its legal guardian. And so the river owns the title to the riverbed, and the people then try and act in its interests. So that's not really, I mean, I can tell you more detail about the body that was set up or the kinds of responsibilities that people have, but you asked about the background, and that's how it arose. So perhaps I'll leave it there, and if you want to know more about the detail, we can do that after Professor Clavijo's had a turn.
Okay, thank you very much, dear Professor Catherine, for your answer. Yes, here in Colombia, we have a similar case in the Atrato River. So we have an expert, Professor Felipe Clavijo Ospina. He had the opportunity to draft the judgment about the Atrato River when he was a clerk in the Colombian Constitutional Court. So, Professor Felipe Clavijo, could you tell us a little more about the context of the Atrato River? And if you want to make a comparison between Atrato and Whanganui River, you can do it. Thank you.
Thank you very much, Professor and Fabio. Well, I think that the Atrato River case is a landmark as well in his own in his own frames. It's in his own framework, because it was a case that proposed by the African Colombian communities that are settled in the Colombian Pacific, very biodiverse place in our country, one of the most biodiverse places in the world as well, but with a very particular aspect. And in that region of Colombia, we have like probably like a resume, or we have in that place many of the problems of our country acting together and against them. You know, like poverty, like violence, like drug trafficking, like displacement, very, very, very complex problems we have in the country, and the people is living in poverty. Historically, our state isn't capable of granting rights, granting welfare, and many things that people needs to have a life with dignity. So it's a very impoverished region that has a very long tradition back in the colonial times, when Spain, the Kingdom of Spain, was the ruler of slavery. Slavery and the commerce of gold, the gold mining, is as old as our country. So that tradition historically has marked that the people, the customers, and the region. So when you can see that even back until 1542, 1552, in Santa Maria del Darién, was one of the first settlements of gold mining in the colonial times, even before the discovering of Minas de Gerais in Brazil. So that was also after that the great or the biggest gold mining in the colony. But the thing is that the people of Chocó, the region when this judgment will take effect, has a very deep root with gold mining.
Mm.
And you can see that on every aspect of their lives, not only with the earrings or, you know, bracelets and the whole kind of thing, but as well as a way to have a spiritual significance in life. They have for a goal uses, traditions, and commons. So it's a very, very deep relationship. So when this action in Colombia, we have a la acción de tutela, is like an instrument, it's a public action, and any person in the country is entitled to present an acción de tutela to prevent or to denounce the violation of a right. And in this case, a very interesting group of communities, African Colombian communities, organized, and they settled this action onto a judge. We have judges in first instance and second instance, and eventually, if the constitutional courts want to make a review on that judgment, they will do it. And you know, and in that case, the constitutional court select the case, and of course, after some time, give us a sentence, a decision. So what these communities of people, well, probably I just need to go back a little bit about the context. In Chocó, in this region, we have mainly African Colombian communities and indigenous communities. But the African Colombian communities act as well as farmers and as miners. It isn't that easy to, you know, to say like we have like here African Colombian communities and we have here indigenous communities. It isn't that simple. So they live together. They share the river. The Atrato River is a very big basin with 18 branches. There are special particular branches where the miners do the whole thing, not in the whole basin, but in a specific branches of the river. So they live together, and African Colombian indigenous communities do very well. The river is linked to every aspect of their lives. It's the only highway possible. You know, there's no roads. It's the river is the only road for many things. Is when people learns to swim and also use the water to bath and also to harvest and also to drink, and as well is the place where the people meet each other and communities meet each other and reproduce culture and build very strong bonds between these communities. So the relationship with the river is a very deep relationship. So when they present this action, it was very interesting because they didn't argue at the moment about every single aspect of the river, but for historic discrimination, and in a way they consider themselves like probably forbidden communities for the country, for the state, historically, for 500 years or 300 years, the least. So they said, we don't have proper education, we don't have proper health, we don't have proper security. And in the last 20 years, we have seen a very concerning habit or practice that now is a very wealthy business, and it's the gold mining. I said criminal gold mining because they use instruments, they use chemicals that destroy nature and destroy the river and the forests and everything. So they said, we have that problem, and without the water, we don't have anything. So at that point, we took the case and said we have to make a visit in situ, an in situ visit, to understand properly this relationship and what happens in this common grounds. And after that, and I will finish with this, we order that visit in situ, and we take a very different approach of the case, interviewing people, navigating the river, flying in helicopters to understand the geography better, and that make a very different picture for us of the case.
Thanks for sharing this experience, Professor Felipe Clavijo Ospina. I think it is useful for everybody, and especially for Professor Catherine Irons. We have some more questions to you. How has the recognition of rights to the Atrato and Whanganui rivers changed the theory of law and its application? Is there a big change or not? Perhaps Professor Catherine, if you want to answer.
So that hasn't changed our, no, I'm going to say, if you look at the basis, let me start again. If you look at what we did it through passing a law through Parliament. We have a lot of treaty settlements, which we call the settlement of those grievances, of breaches of the treaty. We just call them treaty settlements. We have a lot of those, and there's a negotiation between the tribes and the government, and then Parliament passes legislation. So it didn't come through the courts, and we have a system where we have a sovereign Parliament. We don't have a constitution that courts can strike down our laws. We're a bit different from most countries, very different from a civil law country, and very different even seeing the fundamentals broadly, we'll get a lot more of them. I hear there's a mountain that's likely to be announced soon.
Okay. Thank you very much, dear Professor Catherine, for your answer. I don't know if Professor Felipe Clavijo wants to say something about the same question. Yeah.
Thank you very much, Fabio. I think that probably in the 19th century, Savigny, German professor of law, said that the possibility to a non-living entity to exercise rights. So you need lawyers that speak for. So, and in the 20th century, legal scholars design legal personality for huge amounts of money, you know, like in societies and different as a basin or as a river, a forest or a mountain. So I think that we have the with this perspective, we are reinterpreting the classical literature and the classical understanding of legal personality. And I think that probably better new questions to understand new relationships
important to take into account the difference between the common law tradition in New Zealand and the civil law tradition in Colombia. And regarding that topic, I want to ask the following question. Do you think that rights of nature are inherent, natural, and universal rights? And as a result, should they be protected and respected everywhere by all cultures of the world? In other words, do you think rights of nature are natural rights, universal rights? Professor Catherine.
Yes, I think they must be, they have to be, and humans are being arrogant to think that they're not part of the natural world. It's our religions, you know, it's the picture we construct of our place in the world, right, that drives all of these ideas and these laws. And at the moment, most of the people in the world have inherited religions that have put humans at the top, right? The gods are in humans' image. We used to have natural gods. You know, you think we used to all be pagan. And so you ask about the rights. I think if we have a rights framework, then everything in the ecosystem, in the global, you know, ecosystem, everything has a right to live. We're not that special. We shouldn't be seen as that special that we decide, you know, who has rights and who doesn't. So naturally, everyone has a right to live. But I don't like using the rights talk. And that's partly because, again, rights make it sound like we're the ones in control and we have all the power. You know, we grant the rights and we uphold them. So I much prefer to use the concept of responsibility. I know that's meant to be the flip side, right? When you have a right, if you go to government and say, I have a right, you need to uphold it. Well, we're also saying that the government has a responsibility. But if we talk about our responsibilities, then that means we have to be better guardians. You know, we have to uphold the life of nature and think what our duties are more than what our rights are. And then the same goes for nature, you know, and nature, of course, I like the Indigenous concept of seeing nature as a relative, because then the guardianship is like a grandparent, you know, or maybe even a child. But we know we have responsibilities, say, to children, but we don't then, and the children have some rights, but we don't say the children have responsibilities to us, do we? You know, we realize that they don't have the same capacity. And I would use that analogy for nature as well. So we have responsibility. Of course, they have a right to life, just as we do. And we need to change our whole way of being on this earth, or we will destroy it. There's no doubt about it. Our arrogance is what's destroying the natural world around us. So I really like, you talked about this idea of could it change the way we apply law? Could it change the way we think about law? It could, and it should. But before we change the way we think about law, we have to change the way we think about our place in relation to nature and what our responsibilities are. So I hope that that is a little bit diverted, but I hope that answers your question. Thank you, Fabio.
Thank you, Professor Catherine, for your answer. Professor Felipe Clavijo, do you want to say something about this question?
Yeah, very quickly. I am absolutely
yes, please.
Yeah, I am absolutely agree with Professor Catherine Irons. And basically, I think that we need to rethink our notion of rights, our even human rights, because that notion is very wide, very from the north, the global north, and the legal leading scholars in schools of the world. So that are very rooted on the ancient traditions of Roman law and also of common law. And that laws are in a way that laws have allowed this destruction. What we think right now is that environmental law it's a failure. It's a good effort, but it fails. So we need to rethink our concept of law and rights, because as Dr. Catherine says, it isn't about rights exclusively, but also about duties. And our concept of right in itself is very selfish, is very exploitation of the nature oriented. And if we still understand that we can make an appropriation or exploitation of nature and the environment according to economic systems like capitalism, for example, or exploitation of different resources, we won't have any future. So we need to build a very relationship with the nature in harmony, as our or indigenous peoples told us. So I think most important element is to bring these cosmovisions into our understanding of the law, to go beyond our law and probably build a more nature-oriented system of laws and rights, as we said. Thank you.
Well, thank you very much for your answer, Professor Felipe Clavijo. I think it's been a quite interesting podcast. I want to thank Professor Felipe Clavijo Ospina and Professor Catherine Irons for accepting this invitation. In conclusion, I think there is still a long way to go. The recognition of rights of nature is a theory under construction. So we have a lot of challenges ahead. We have to change the mentality of Western legal culture, perhaps. Also, we think that rights of nature are natural rights and universal, and rights inherent to the nature. And also the idea is not to see the nature as a way to satisfy the rights of human beings. The idea is to see the nature as an end in itself. So thank you very much for your time. I enjoyed a lot this podcast. Thank you to our listeners. I will see you in other opportunity, dear Professor Clavijo and dear Professor Catherine. If you want to say something to end this podcast, you can do it.
I'll just say thank you, Fabio. It's been most enjoyable, and yeah, I've been honored to be airing on your podcast in Colombia. Thank you. Gracias.
Thank you very much. Thank you very much, dear Professor Catherine and Professor Felipe Clavijo. Do you want to say something?
Yeah, thank you very much for your time, the space. It was so fast. It was so quick. But it was, I think, the first of many other discussions and debates about rights of nature. And what we need, one final thing is rights of nature is a methodology, even a movement. So we need to enforce and to give content to that movement to change our common understanding of Western law. Probably from a perspective of the global South, we don't know, but we need to continue this conversation.
Maybe I should make my last words that if someone can come up with a better name than rights of nature, that would be helpful. I know it speaks, as soon as you say rights of nature, everybody knows what you mean. So it has a lot of power and it looks subversive. It looks like it's a great label for a movement. But at the same time, as Professor Clavijo mentioned, it alienates those who think that responsibilities and communities are more important, right? And not individual. And you've got to have more focus on the community and the group than the individual, and the community includes nature. So I don't know how we can get responsibilities in there more, but if people have a better idea, maybe you can come up with one in Spanish that does it better than English. Kia ora.
Well, it is true. Thank you very much, dear Professor Catherine. So have a nice day in New Zealand, a nice day in Colombia. We will see you in other opportunity. Thank you very much.
Thank you. Have a great day.
Bye-bye.